Okay, well, thanks for joining us tonight. I'm Miranda Hess from Lehigh County Administrative Entity, and myself and Emily are the co-facilitators for the Lehigh Valley Supporting Families Collaborative. I'll let her introduce herself.
Hi, everyone. I'm Emily from Northampton County. We have, some good information going out tonight. We have Leslie from McAndrews Law Firm. I'll let her introduce herself. She has, content ready to show, and this will also be going out with the recording. So if anyone wants the slides, they'll be out.
Okay, am I good to go, Emily? Awesome. Hi, everybody. I'm Leslie Mahalik. I'm an attorney with McAndrews Law Offices. So I'm in private practice and I handle all kinds of estate planning, but our firm really has a focus in special needs planning. So our firm does special education work, helping kids get the services they need in school. And then I am on our estate side. So again, I do a lot of estate planning for families who have a child or family member with special needs. So that is all that we're going to be talking about tonight. And I have a lot of material to go through here. I do my best to make PowerPoint slides that really are going to be useful for you. So like they said, I've provided my PowerPoints to the organization. They'll have them available for you. So you'll be able to see those. And we are going to cover a lot tonight. We're going to do kind of a brief overview of public benefits, and then we're going to talk about the 3 different types of special needs trusts. We're going to talk about the 3 different types. Then we will talk about the uses of these trusts, how they work, can they buy a house, stuff like that. And then we're going to conclude with the ABLE account, and we'll talk a little bit about the differences between special needs trusts and ABLE. So it is a lot of information, but again, hopefully it'll be useful for you. And, any questions that you have, again, if they're general questions, please go ahead and put them into the chat. I have the chat up, so I will see them. As long as it's something that I think I can answer as we're going along, I'm happy to do that. Any more specific questions we would hold until the end. So I am going to share my screen here so everybody can see our presentation. And we will do a little slideshow. All right, so here we are. And let me just pull the chat back up. Okay, excellent. All right, so we're going to be talking, all about estate planning, particularly if you do have a family member with special needs. So we'll be talking a lot about special needs trusts. So why would we even use a special needs trust? What's the purpose of it? Well, special needs trusts are really unique because they really are the essential and main vehicle that can hold monies for a person with special needs who is getting public benefits, but still allow those monies in the trust to be available for the individuals, for really anything the individual might need above and beyond what public benefits provide. As we'll see when we talk about public benefits are very important. They do provide some of the bare essentials of life, but that being said, what they provide is limited. So a special needs trust is such an important tool because it really can provide so much for a person with disabilities above and beyond what they might get from just public benefits alone. These trusts can really be used to increase the quality of life and enjoyment of life for persons with special needs. So they're extremely important tools, and we're going to go all through them tonight. So anytime we are talking about a special needs trust, it is important to note that they're generally only going to be appropriate for persons who are disabled. And when we use the word disabled in this context, we really are talking about the Social Security standard. Now, it's important to note that a person does not have to be determined to be disabled under this standard in order to use a special needs trust. That being said, we do need a good faith basis that they would generally meet this standard. So I have that standard here on this slide. As you can see, it's different depending on how old the person is. So while somebody is a minor under age 18, the standard is much more flexible and it's frankly a lot easier to fit into this standard. So while the person's under age 18, they do have to have a physical or mental impairment that results in marked and severe functional limitations. So marked and severe functional limitations, as you can see, that can be a standard that a lot of different types of disabilities can pretty easily fit within. Once the person becomes an adult, however, and they turn age 18, under Social Security's eyes, they're in the adult system. And at that point, they would have to fit under the adult standard. And for the adult standard, it really turns into more of an economic standard. So regardless of what diagnosis the individual may have, the standard Social Security uses is that, again, they have that physical or mental impairment. It is supposed to be an impairment that's going to last at least 12 months or longer. But because of that impairment, the person's not able to work and earn enough money each month. So Social Security puts out a number every year. You can look this up. It's called the Substantial Gainful Activity Amount, SGA. You'll see it abbreviated too. And that is just a monetary amount. For 2024, it's somewhere in the range of $1,500 per month. But basically, Social Security says that the individual has to have an impairment that prevents them from earning that much in gross earnings on a consistent monthly basis. So that's what you have to show. As you can imagine, if you do have a child who is high functioning, sometimes that standard can be hard to prove. Social Security at first blush may say, no, we think you can work and earn that much. So you may initially be denied for benefits and have to appeal that decision. Because of this is one of many reasons that we really do urge clients to go and apply for Social Security as soon as they can once the child turns age 18. Prior to age 18, a parent's monies are going to be deemed to the child. So the child may not be financially eligible for certain types of Social Security benefits. But after age 18, they're only looking at assets in the child's name. And we do urge families to go and apply soon after age 18. If you are initially denied, you'd want to appeal that decision. And, if you're denied a second time, you want to appeal it again. You basically want to keep that appeal going until hopefully the person is approved. You may need to seek some legal counsel if you're really having trouble. I don't do that area of law, but there's a lot of great attorneys out there who do. And as long as you keep that appeal going, once the person is officially approved, then they are approved back to that initial application date. People don't always realize that, but what happens is if you drop the appeal and the individual is denied and you don't keep going forward on the appeal, then when you reapply, you're looking at that new application date. So we will talk about the public benefits here that are available if you are disabled under that standard. And from the Social Security side, we're looking at Supplemental Security Income, or SSI. SSI is a really important benefit. It is available if a person is disabled under that standard and they have very limited financial resources in their own name. specifically if the person's not able to have more than $2,000 in their own name. That is a really low limit. And that resource limit, that $2,000, has been in the law for decades. It has not increased for inflation. It has not changed. We have had some pending legislation that would increase that resource limit, but the last time I checked, it hasn't had a good likelihood of passing. So at the moment, we're really stuck with that $2,000 resource limit. But to qualify for SSI, a person does not need to have any work history. As long as they are disabled under that standard and they have less than $2,000, they can qualify for SSI. If they do qualify for SSI, they will start getting a monthly check from Social Security. The maximum amount an individual can get in 2024 is $943, but that benefit can vary if the individual has any income from any other sources. And again, it's important to note that under age 18, a parent's monies are going to be deemed to the child. So the child may not qualify under age 18 if the parents are working. But once the child is 18, we're only looking at monies in the child's name. So it is also important to, just make sure that while the child is a minor, you're not putting accounts into the child's name. A lot of very well-meaning parents might do that, but unfortunately that can create problems for benefit eligibility down the road. Now, in Pennsylvania, if an individual gets $1 of SSI, they are automatically enrolled in medical assistance. There we go. And medical assistance is what we call it in Pennsylvania. Federally, it is known as Medicaid, but the two terms are really interchangeable, so you can, call it either. I call it Medicaid a lot. It's just a little bit of a shorter word to say than medical assistance. But medical assistance is both a federal and state program. There's federal laws about it. But it is administered at the state level. So it's administered through our county assistance offices. And medical assistance is very important. It's really the broadest source of healthcare coverage that we have in the United States. So for purposes of there's a lot of different types of medical assistance out there, a whole bunch of different categories of it. But for the purposes of our discussion, for the type of medical assistance that an individual can get if they are disabled and they have less than that $2,000, we're really looking at the same eligibility requirements as we are for SSI.
Leslie, we had 2 questions come in the chat regarding income and what counts towards the limits and whatnot. So the first question says, does child support count against the individual's income if they are 18 and still in school?
Okay, so child support will count against it. While the child is under age 18 and a minor, it's only a portion of the child support that would count against, let's make sure I don't have a slide on it. It's only a portion of the child support that would count against it. I believe it is 1/3 of it that would count against it. Once the child is an adult, however, and out of school, at that point, if the child support continues, if the family agrees to continue making those payments, then the full amount of the child support is deemed as income to the child and would count against their monthly SSI payment. Now, there is a way around that. Social Security will allow us to do what they call an irrevocable assignment of certain streams of income. So we can't do this with just any stream of income. Like, let's say the child had their own IRA or something like that. We're not allowed to do it with that. However, for child support, for alimony, and then also if you happen to have a military survivor pension, For those three different streams of income, Social Security will actually allow you to make an irrevocable assignment of the entire stream of income directly into a special needs trust. Usually you have to do that through a court order. So if you do have a child support arrangement, typically what you would have to do is go back to your domestic relations attorney, have them, enter into an agreement, get that agreement approved by the court, and then show that to Social Security. And then what would happen is moving forward, the child support payments would go directly into the special needs trust. It can still be used for the child during their lifetime, but the payment would go directly into that trust. And then none of the child support payment would be counted against SSI.
Thank you. Another question we have as well is, does a UTMA count against the SSI limit? I'm not familiar with what UTMA is, but maybe you do.
Yeah, it's a uniform transfer to minors account. It's an account, it's a custodial account for minors, and a lot of families will set these up for minors. So the rule with those is, as long as the child is a minor, and get this, as long as the account is not used for the child during minority, then it's no problem. The child will continue to qualify for the SSI. However, once the child is of the age of majority, and in Pennsylvania for the UTMA accounts, it's age 21. So those accounts are not a problem for the child until age 21, as long as the account, again, is not used for the child. But at age 21, that account is fully available, meaning it would be fully available and countable against that $2,000 resource limit. So with an UTMA account, we basically are going to need to, spend it down prior to that age 21, or like prior to age 18 if the child is going to need to qualify for benefits. Or once the child is of age, we could move it into a type of special needs trust. But great questions, guys. Okay, and I see one more. Let's just.
I was going to say, can you claim adult disabled child as dependent on your tax return if they receive SSI and Medicaid, or will they lose their benefits?
Oh, yeah.
So that's a little bit of an accountant CPA question, because I usually don't do the income tax returns. However, that being said, I'm like 99% sure that yes, you can claim your child as a dependent and still allow them to get their public benefits. I believe I have lots of clients that are doing it that way. I don't think it's a problem. Okay, so just another Medicaid program to be aware of, just because I feel like people aren't always made aware of these programs. If you do have a child who is able to work, and it can be a limited amount, but if they are working, there are two programs out there. The first is medical assistance for workers with disabilities. This is another type of Medicaid that is specifically for individuals who are able to work but are still disabled. And this has a higher resource limit. So you can have monies up to $10,000 and qualify for MAUD. And then we have a brand new program called Workers with Job Success. This was brand new from last year. In order to qualify for this one, you already have to have been on MAUD for 12 months, but it has an even higher income limit and actually no resource limit at all. Now, both MAUD and Workers with Job Success are cost sharing programs, meaning you have to pay premiums, and a premium amount is going to depend on your income amount. Oh, great. And I see we have a comment in there, exactly that. This person does claim their adult child as a dependent on their tax return, and the child still receives SSI and Medicaid. So thank you for that. And I'm glad my instinct is correct on that one. Okay, so in addition to SSI and Medicaid, remember, SSI and Medicaid are the benefits where we cannot have more than $2,000 and still qualify for them. They also have pretty strict income limits. So depending on your income, your benefit may be reduced or potentially eliminated. In addition to those, there's also SSDI and Medicare, and a lot of your children may end up getting these at some point in their life too. So there's two important ways that our clients are going to qualify for SSDI and Medicare. The first is off of the person's own work history. So if you have an adult child who is disabled but is working, if they're paying into the system for enough quarters, then eventually they may qualify for SSDI, Social Security Disability Insurance, based off of their own work history. And then anytime a person's getting SSDI for 2 years, 24 months, 2 years, they will start getting Medicare as well. The other way people qualify for SSDI is based off of a parent's work history. So there is a special category out in the law out there in Social Security rules called Disabled Adult Child, DAC. This is a very important category. The way a person qualifies to be in this disabled adult child category is if they are determined to be disabled prior to age 22. So they do have to meet that standard that we talked about earlier, that economic standard, prior to age 22. And to be honest, the easiest way to get into this disabled adult child category is to actually get SSI prior to age 22. So this is, again, one of those reasons that we really urge parents to go and apply for SSI right at age 18. Because the easiest way to prove you're in this category is, to simply get SSI before age 22. So if you do that, then later down the road, once the parent retires, then the child is actually eligible to take SSDI based off of the parent's work history. So what happens is the child will be getting SSI for a number of years, and then when the parent retires, their check will increase. It's going to switch to SSDI, and they'll start getting a much higher check. Now, this disabled adult child category is important because it has a Medicaid loophole. So even if you start getting so much SSDI that would normally put you over the income limit for Medicaid purposes, you'll still qualify for Medicaid. So you might start getting, say, $1,800 a month or something of SSDI. That's normally over the Medicaid income limit, but that child's going to keep receiving their Medicaid benefit even despite this higher income limit. So that's a really important category. So again, the SSDI and the Medicare themselves are not resource dependent. Technically, you can still have assets in excess of the $2,000 and qualify for those. However, we generally want to keep your resources below the $2,000 because we have a lot of clients that are dually eligible for the Medicare and the Medicaid. And remember, Medicaid also has with it those Medicaid waiver benefits, which are those important benefits to provide supports and services to keep people in the community or potentially in like a group home, but it's in a community setting versus the institutional type of setting that we had back in the 1970s, which is not where we want any of our family members to go.
Question, after 24 months of SSDI, is the disabled adult child automatically enrolled in Medicare or should the payee apply?
They should automatically get it, but what I sometimes see is clients do actually have to advocate for that. So it's something to be aware of and to possibly follow up with Social Security on, because sometimes I feel like it gets missed.
And follow-up question, can the disabled adult work?
Sure. Yeah, they absolutely can. But depending on the benefit that they get, you may have to monitor how much they are working and potentially reduce their working hours.
And I think we have another one that just came in. If you applied for SSI when they were 21 but was not approved by SSI until the age of 22, will they be eligible for the DAC?
Right. So as long as your application date is prior to age 22 and you, like I said, kept that process going. So if you were denied, you appealed it. If a determination that they are disabled comes in after age 22, then yes, they will still be in that category. Yeah, so that's really important. You always can go back, like let's say you never applied until your child is 30. You can always go back and try to prove it. You can employ like a forensic psychiatrist or something like that to show the child was disabled at that age. But that being said, just the easiest way is if you actually were getting SSI prior to that age. And then the one other thing I would note is the other, another very important reason why we do urge clients to apply early on is just to have the child in the system and enrolled. Sometimes it's hard to get these benefits. It's hard navigating these systems. I know you guys do so much work, while your child is a minor, going through the school system and learning all of those rules and, everything. And then once they transition into adulthood, you're looking at a whole new system, whole new set of rules. But it's really best if you can kind of plan for the future, have the child get as many benefits as they can, just because if something were to suddenly happen to the parents, it can really ease things for the next caretakers.
I guess just a couple comments. I don't know if Leslie, if you'll have anything to add, but nonetheless, for the sake of the presentation, one parent said, I think that was confusing when we started with SSDI. It was not clear if we needed to stay below the $2,000 limit for the MA waiver. So thanks for clearing that up.
Yes,
Another
you do.
parent said, I was told by Social Security that you have to apply for Medicare. It doesn't happen automatically, but these answers sometimes depend on who you get on the phone. So
Unfortunately, that's true.
yeah.
And
Yeah. And another comment by another parent, our disabled daughter over 40 years old has worked part-time long enough to receive Medicare and SSA. She started receiving SSI at age 18 and is considered DAC. She recently lost her SSI because her SSA plus dad's SSA added when he retired. Will she lose Medicaid benefits in Pennsylvania?
No, she will not. She should keep those. Absolutely. You've done everything correct. She's in that disabled adult child category. You do lose SSI once you start getting like more SSDI. So like again, the max SSI right now is that $943 per month. So if she had a limited work history, let's say maybe she started getting, say, $400 a month of SSDI. In that case, she would still have gotten SSI to bring her up to that 943. But now that she's getting SSDI based off of her father's work history too, that's going to put her in over that 943 a month. So she just won't get SSI, but she will still get her Medicaid. And if they terminate you, because again, as we're seeing, sometimes you get misinformation or mistakes are made. If she is terminated, that should be appealed because she's absolutely eligible for Medicaid still. Okay, so we said you can only have that $2,000 resource limit. That's liquid assets. Just keep in mind you can have what they call excludable resources. So those are your principal residence, your one vehicle, a prepaid funeral, any type of tangible personal items, term life insurance, things like that. So those will not disqualify the individual. All right. Let's see.
Quick backtrack before, sorry, Leslie. We have a parent says, my son who is a DAC was taken off of Medicaid because they said his Social Security amount was too high. His Social Security monthly benefits are under $1,700. Why has he been repeatedly denied Medicaid?
Yeah, I mean, that's wrong. It just is. If he is in that disabled adult child category, Medicaid made a mistake there. I just handled an appeal for a case exactly like that. We appealed the Medicaid process. It had to be taken to a fair hearing, but we were able to work it out because Medicaid just messed it up. Now, unfortunately, it wasn't cheap for the family to appeal it. I mean, I had to do a good amount of work to undo it. Which I'm sorry to say, but we did it. I know.
Well, hi, Debbie. My understanding is that there is still an income limit for receiving MA as a DAC.
Well, yeah, Medicaid does have income limits. Yes. So again, you are able to work, but if you're working too much, then you could lose Medicaid. Medicaid still has income and resource limits. For the different types of Medicaid, they can vary depending on what it is. The income limit's higher for just waivers than regular Medicaid. So there are still income limits. And resource limits for Medicaid, not for Medicare as much. I mean, there's still, yeah.
Yeah. Another question we have here, are there asset limitations associated with CDBR benefits?
I don't know what the CDBR is off the top of my head. Yeah.
Okay.
Oh, and Emily, is it all right if I just throw out a potentially helpful resource, particularly for this person that was denied of Medicaid? So guys, just one really great thing out there. They have a wonderful website and they will do like pro bono legal services, is the Pennsylvania Health Law Project. I think the website is like phlp.org maybe, but if you Google Pennsylvania Health Law Project, they're really great. They have like a hotline where they will take questions. And like I said, for free, they do some like just pro bono legal work, but they're also just a great resource that'll really talk to you all about like Medicaid and those rules. So I'd suggest that you take a look at their website and maybe reach out to them.
I'll put it in the chat. I was able to find their website. So.
Oh, great. Yeah, they're wonderful. Really, really good. All right. So with that, we're going to go through our special needs trusts. We're going to start with third-party funded special needs trust. So this is the type of trust. We call it third-party funded. It's also often called a supplemental needs trust. Same thing. This is the type of trust you'd set up as part of your estate plan. When we say third-party funded, we mean that the monies that are going into this trust are from literally anybody in the world except for the person with disabilities. So like you're never going to put his SSI check into this trust, or if he had an UTMA account, that's the child's money. We can't put that into the third-party funded trust. But instead, mom and dad can leave their monies in this type of trust. And, you know, these trusts have been around since about 1987. There's a Pennsylvania case that established them. Before these trusts were available, parents really were only left with the option of disinheriting their child with disabilities from their will. You can still do that. That's still valid. It can still work. It might be right for your family situation, but now you don't have to. What can happen sometimes, you know, when you do disinherit the child with special needs, you leave money to other children hoping that they will use it for their sibling with special needs. You know, unfortunately, we just can't guarantee that's going to happen, right? Like if the non-disabled child ends up getting divorced, that money can go in a heartbeat through equitable distribution. Or just if they're a spendthrift, if they like going to the casino, maybe they marry somebody who doesn't want to use the money for the disabled sibling. Maybe they have a bad business deal and they have to go through bankruptcy, whatever it is. We just can't always guarantee that. So now what you can do is through preventative planning. So this is planning you have to do through your lifetime. You can set up one of these third-party funded special needs trusts, and you can direct that all of the monies that you want to go to your child with special needs will go directly into this special needs trust upon your passing. As long as you set this up ahead of time, we can do a really broad trust, a nice trust with favorable terms. There is no payback to the state for any Medicaid provided to your child, no payback at all. Upon your child's passing, the monies in the trust can go wherever you would like them to go. So they're really great. The whole purpose of this type of trust, and really all special needs trusts, is that they are supposed to supplement public benefits and not supplant them. So you'll see that type of language in the trust. They are supposed to be used for things above and beyond what public benefits will provide. But as we'll see, they can be used very, very broadly to really benefit that child's life and, just really enhance their future.
Leslie, I think we might backtrack a little bit.
Sure.
We had someone ask if there was an equivalent of the Pennsylvania Health Law Project in Maryland. I'm not sure if you're familiar, depending on where you practice, but
yeah, I'm licensed in Maryland, but unfortunately, I just don't know. Yeah, I'd have to look into that. But they might know. You could always reach out to them and see. They might know.
And then the parent clarified on the CDBR. For clarification, it is Childhood Disability Benefits Retired Number Holder, CDBR. So I don't know if that is that.
Yeah, no, I'm sorry. I'm still not familiar. Is that a type of Social Security, or is that through like a retirement program that the parent has? If we are talking about that disabled adult child benefit, again, there's no strict asset limit for that. However, there certainly is for Medicaid. So often the driving question is whether your child needs Medicaid, because there are still resource limits for Medicaid. And, truthfully, the answer is usually yes. So anytime you have multiple sources of health insurance, Medicaid is always the payer of last resort. So if you have private insurance, if you have insurance through the exchange, if you have Medicare, they're going to come in first. But Medicaid picks up things that other types of insurance don't cover. And again, in addition to Medicaid, we have those waiver programs. So, if mom and dad aren't here anymore, those waiver programs are very important. They can provide like case manager services, just oversight, in addition to like attendant care or nursing care, or again, like group home. So usually we are still having our clients qualify. Okay. Any type of, I'm sorry, Emily, I still had that open. So I did see a question about explaining the last bullet point on the slide there. Any type of special needs trust has to be what we call fully discretionary. That means the trustee has to have the full ability to make or withhold payments. So in a special needs trust, any type of them, we can't say that all income will go to the beneficiary, or we can't like give the child an allowance per se. It can't say the child will get $500 a month from the trust. We can kind of work it out that way, but the trust cannot specifically state that. So that's what that means. All right, there's two different ways to set up these third-party funded trusts. Both are absolutely fine. It just depends on your situation and your needs. But we can do it as a trust under the will. That means that the trust is actually contained within your will. So you have one document, your will, and it has special needs trust provisions. That means that that trust does not come into existence until you pass away. That's when that trust would be set up. The other way to do it is what we call an inter vivos trust. That just means that you set it up during your life. So in that case, you have two documents. You have your will, and then you have the trust. The benefit of doing it that way is that other people can name that trust in their will as well. So when it is that inter vivos trust, it gets set up when you sign it. It doesn't have to be funded. So you don't have to open a bank account until you're ready to put money into it. But that does allow other people to name that trust too. So like, let's say there's a grandparent that wants to leave $5,000 to the special needs trust. They can just name the inter vivos trust that you've already set up. Okay. Oops. Now, anytime you're doing this type of estate planning, it is absolutely essential that you coordinate your entire estate plan with the special needs trust. So, there are certain assets that pass under your will. They're called probate assets. Those are generally bank accounts, your house, all things that are titled in your name alone. Other assets are called non-probate assets. Those actually pass outside of your will, and it doesn't matter what your will says. We have to make sure our non-probate assets are going to pass to the special needs trust too. So specifically, non-probate assets include assets that pass by beneficiary designation. So that's your life insurance, and it's any type of IRA or retirement plan. Those are going to pass directly pursuant to the beneficiary designation. So if you do this type of planning and you create this third-party funded special needs trust, you also have to update the beneficiary designations for all of your retirement assets. So instead of just saying to my spouse and then my children, you instead have to say, any share for my son is going to go directly to a special needs trust. So that's really important. And then also, like I had mentioned, we have to watch for any accounts that are already in that child's name. Depending on the type of account, it's going to depend on how it would be treated, but we have to make sure we consider all of those. And just one last note, on those retirement plans, a few years ago, there was a change in the law. There was a law passed called the Secure Act, and that changed how inherited IRAs are treated. In brief, it said if you have a non-disabled child and you're leaving an IRA to that child, they now have to take it out over a 10-year period as opposed to over their lifespan, which was the previous law. But there was an exception in that Secure Act. It did say if you are leaving an IRA to a child with special needs, which we wouldn't want to do outright because, again, that's going to, render them ineligible for public benefits. Plus, it's giving them money in their own name. And a lot of our children with special needs are vulnerable to bad actors out there. So we want to protect their money, and we can do that by putting it into the special needs trust. So if we leave the IRA to a special needs trust, a properly drafted special needs trust, it can still get the benefit of that lifetime stretch. We can stretch it out over the child's life expectancy. So there's still some other complicated income tax ramifications when we do that. So we'd really look at that carefully, based on your unique circumstances to see if it made the most sense. But just keep in mind that that is something that can be done. Okay, let me just
let's say quick question in the chat. Can a child have more than one special needs trust, for example, if parents are divorced?
Absolutely, yes. You can have as many special needs trusts as you would like. We're going to talk about the ABLE account once we finish special needs trust, and you'll see you can only have one ABLE account, one. But for special needs trust, you can have many. And we have a bunch of cases with divorced parents where the parents want to have two different special needs trusts. That way you can have different terms. You can put a different trustee in place depending on what you would like. All right, guys, so we talked about those third-party funded trusts. Remember, those are the ones where we can't put the disabled person's own money into. So now we're going to talk about the two other types of special needs trust where if the disabled child has money himself, so let's say there was an UTMA account that was funded that we weren't able to spend down. We had generous grandparents. They put $100,000 into an UTMA account, but now our child is age 21. We have to do something with it. What do we do with that money? Well, we could look into moving it into what we call a self-funded special needs trust, self-funded. So self-funded, again, means that it's funded with monies of the disabled person's own. So these are much stricter trusts. These are trusts that are set up under federal law as well as state law. And again, these are we're only going to put the disabled person's own money into this trust. There's a lot of rules about these types of trusts. They have to be drafted for the sole benefit of just one disabled person. They have to be fully funded before the person's 65. So if you're over 65, we can no longer use this type of trust. These trusts have to be established by a certain person. It can be established by the competent beneficiary if he is a competent adult. And if not, then we're looking at the parent, grandparent, legal guardian, or the court. These trusts have to be irrevocable. And then very importantly, these trusts must have a payback to the state for all Medicaid provided to the beneficiary during his lifetime. So the way the law works is they do allow a disabled individual, as long as he's under 65 and he otherwise qualifies, they allow him to move his monies into one of these self-funded trusts and boom, immediately become eligible for public benefits. But they say when he passes away, if there's any money left in that trust, it first has to be made available to the state to repay it for all Medicaid provided to the beneficiary. No payback for SSI or SSDI or Medicare. It's only for Medicaid. And the payback is only for actual Medicaid provided to the beneficiary. Medicaid pays like pennies on the dollar of what private insurance would pay. Medicaid has negotiated rates with providers. So the payback might be lower than you might expect. But that being said, if the person had like a lot of surgeries or if they were in a group home for years, it could be an expensive payback. But that's the way the law works with that.
We have a couple questions. You're doing great, so thank you. We just completed an interview of third-party trust. We were told that we could use this third-party trust to pay rent because she has SSDI. However, if a person has only SSI, then the third-party trust can't pay for rent. Can you confirm this?
So we didn't go into it just because we only have so much time, but with SSI, and let me just see if I have a slide on it. I actually do. Okay. Here, Emily, let me bump ahead. With SSI, what they say is your $943 of SSI, if you get that full amount, is supposed to be enough to pay for all of your food and shelter. Now, the food rule actually just went away as of September 30th, which was Monday. So now it is just shelter. I'm sorry, I did not update my slides since Monday. And this is a reason to always talk to somebody that knows what they're doing in this area, because these laws are like always evolving and changing, and it's just a fact of life with Social Security and Medicaid. So basically, Social Security says your SSI is supposed to be enough to fully cover your shelter costs. However, it's not always the case, right? It's just not enough money to fully pay for like rent or something like that. So anytime an SSI recipient has their shelter costs paid for by another person, this could be if a special needs trust pays it, this could be if mom and dad pays it, this could be if an adult disabled child lives rent-free in mom and dad's house. In any of those situations, Social Security counts that as a special type of income. It's called in-kind support and maintenance. We abbreviate that as ISM. But this ISM is just another type of income. And what Social Security says is if you are having your shelter expenses paid by a third party, then they will reduce your monthly SSI payment. But the good news is that they won't eliminate your SSI. They're only going to reduce it by this presumed maximum value amount. And what that is 1/3 of the total SSI payment plus $20. So in 2024, they'll reduce it by $334.33. So that rule applies whether, the special needs trust pays it or otherwise. As we will see, there is another exception in the law. An ABLE account is actually able to pay these shelter expenses, and it's not treated as this in-kind support and maintenance. It's not treated as ISM. So if an ABLE account pays the rent, there's no reduction in SSI. But if anybody else or any trust pays it, then there is a reduction in SSI. So, sometimes what we tell our clients is if you do have an adult child living in your house, you don't want it to be rent free. So, if they are getting SSI, you should charge them rent every month. So, have that child pay, you say $500 per month of rent. They pay that to you. That's now your money. You could, if you wanted, use that money and fund the third party funded trust from that. Normally, you can't just put their SSI directly into the third party funded trust, but if they pay it to you as rent, it's now your money. So you could put it into the third party trust. Okay. Did I fully answer that? I think so, right?
Yes, it's just there with SSDI, I believe these rules change. Is that correct?
Yeah, we don't have any ISM problems if you're getting SSDI. Yeah, it's yet another benefit of being in that disabled adult child category because as you can see, you have to do a lot to stay eligible for SSI. The SSI program is strict. Social Security really monitors it, and it can be difficult. So if we are switched to SSDI, then that's all gone.
I guess we have a couple of questions here. Is there a firm or organization in the Valley we can set up an appointment for our individual family needs, whether it's state benefits or parents leaving money?
Oh gosh. Well, I'm happy to help you, but I'm not in the Lehigh Valley. I'm in, Berwyn. Otherwise, you can just search online. There's plenty of good organizations that PHLP may be able to direct you as well.
I guess we have a little bit more feedback on the CDBR and CDBD or SSA claims. They define Title II benefits that the disabled individual currently receiving SSI becomes eligible based upon the retirement of the number holder, CDBR, or the number holder becomes deceased, CDBD.
That actually sounds exactly like that disabled adult child benefit that we were discussing.
Yeah. Does the payback apply before the first party trust is created?
No. So we only have Medicaid paybacks when there's a statute that requires it. There's a few of them in Pennsylvania. One you might be familiar with is the Estate Recovery Act. That's like if you're in a nursing home and Medicaid's paying for it. And you pass away, there's a payback for Medicaid provided over age 55. Another one is with these self-funded trusts, but there's no payback before that. It's just once that trust is funded, if the trust ends, which is usually when the person passes away, at that point, there is that payback.
If a person received a third party funded trust eventually passes away, can they leave it to a family or beneficiary?
Absolutely. You can leave it to family members, to a charity, anywhere you want.
The same person also mentioned that their daughter's SSI was just reduced by the 334, even though nothing in our or her living arrangement has changed. And I guess last question for now, can you put the SSA survivor benefits in a special needs trust or ABLE account?
Okay, so I would make a note that they should go back to Social Security, although I know it's difficult. I'm sorry to tell you, but you go back, tell them you are charging the child rent. You can do a one-sentence rental agreement, as of November 1st, 2024, I'm charging my child $500 a month rent or whatever number you think is appropriate. And tell them, and they should modify that. Again, I'm sorry that happened. If it was reduced by the 334, that's why they deemed that ism. And what was okay, Social Security survivor benefits. So if it is the child's own money, so any type of Social Security the child's entitled to from any, as long as it's going to them, that's their money, that cannot go into a third party funded trust. It would have to go into a self-funded trust. In general, we recommend that the person's Social Security be used for their general day-to-day living expenses. So you want to use that money first, and then, excess money in the trust would be used above and beyond that. Now, the individual can put their own money into either that self-funded trust or the ABLE account. They also could put it into this pooled special needs trust. I just want to touch on this real quick. It's just another type of our self-funded trusts. It's really a handy option if the person's getting, like, let's say, a smaller amount of money. Maybe they're getting $25,000, and you don't necessarily want to set up a whole self-funded trust. You might look at the pooled special needs trust. It is one that has to be run by a nonprofit fiduciary. There's several of them in Pennsylvania. Every state has several of these. But that nonprofit already has a master trust agreement that is set up. And you can just sign a joinder agreement to participate in the pool. They maintain a special account just for the individual during his lifetime, but when he passes away, it depends on what your master trust agreement says, but in general, the funds are going to revert to like the master general account for the pool trust, and they're made available for other persons participating in the pool. So we generally don't have people use that for, really big amounts, but for smaller amounts, it can be a really great tool. I have my cats here are causing a little bit of havoc, so I'm hoping you're not getting excess noise. If we need, I can shut them out of the room here, but they're kind of running around. Okay, that's what I looking over. I'm like, it's that hour where they're just, I don't know.
No worries.
Running around a lot here.
I guess before touching on this slide, we have a question. Is there a limit on how much rent could be charged to a DAC receiving SSDI?
No, there really isn't. I mean, you should have a general fair market value basis for charging it. But no, there isn't a limit to it. And before that food rule went away, we were usually having people charge room and board. You could still, do that. So if somebody's getting SSI, it's, not hard at all to use their full SSI amount. But if they're getting a higher amount of SSDI, there's no limit. You do, want to leave them some monies that they can use, like I said, for their spending money and things like that. Because what we're going to see is the special needs trust cannot pay cash to the person. So instead, we do want their Social Security to be their spending money. So on this slide, we're just talking about what the special needs trust can purchase, and it's truly extremely broad. I have just a couple examples listed there of like clothing, a car, a driver, any type of transportation, any type of electronics, computer, cable bill, cell phone, a vacation for them and the persons who are needed to care for them, make sure they're safe on the vacation, any type of entertainment things, a burial reserve, all of that. As long as it's, for the individual, for his primary benefit, then it's going to be fine for the trust to expend to purchase that for him. So it's almost even easier to talk about the things the trust can't do. And they're really limited, but there are a few rules of what these trusts cannot do. And this holds true no matter which type of special needs trust we're talking about. So the first thing is what I just said, no cash. These trusts are not ATM machines. We cannot give cash to the disabled person. Cash is treated as income. It will affect their Medicaid. It will affect their SSI. So it's just kind of a no-no from special needs trusts. So instead, they are going to use their Social Security as their spending money. And then the trust is going to be used for things above and beyond what that Social Security can provide. Now, when I say no cash, we generally are going to have the trustee, that's the person, or it could be a company that is going to administer the trust. So they invest the trust money, but they also make distributions on behalf of the beneficiary. The trustee is going to generally make payments directly from the trust. So if there's like a monthly cell phone bill, the trustee is going to pay that bill directly from the trust account. We're not going to give the beneficiary cash to pay the cell phone bill. The beneficiary, if they are a competent adult and they can do this, they can use a credit card to buy things for themselves, and then the trust can pay the credit card bill. And then the other rule is no major gifts to the other people. These trusts are for the disabled beneficiary. So, we can buy him a car, but we can't just buy somebody else a car. We're not giving, $2,000 to a friend or anything like that. In general, that rule just really serves to protect our disabled beneficiaries. Again, it's a vulnerable population. And it can be nice for mom and dad to know that even in the future, even if their child says, oh, I made a best friend and he just really needs $5,000, I want my trust to do it. Trustee is going to have to say no. That's just not allowed from these trusts. Now, if your beneficiary really wants to purchase like a very modest, reasonable gift at a customary time, like let's just say a birthday gift or something like that, if it's reasonable, if they're getting enjoyment from doing that shopping, it's okay. But we're not buying, super expensive fancy watches or something like that as a gift.
We have here, I guess when it comes to the expense of health supplements, if the special needs trust can pay for that. I know you mentioned like.
Absolutely.
Yeah.
Absolutely. And sometimes those are really expensive, or we'll have a beneficiary that like can only have certain types of food or has a restricted diet or, whatever it is. Absolutely. The trust can pay for that.
And how is a trustee educated on these guidelines?
Yeah, so there is a lot of information out there. You just have to be careful with what you read online because it may not all be current. It may not all be, applicable in your situation. If our office prepares a trust, we do a real comprehensive letter of instruction. We provide some articles along with the trust that are really useful. There is a resource that we generally give to our clients. I think it's called a handbook for trustees or a handbook for special needs trusts. Emily, maybe you can try to look for it real quick and see if you can find it. But it's a free document. It might be through like the Special Needs Alliance, perhaps. I download it every year and I hand it out to clients because it is really useful. So that's a resource. My firm's website also has a lot of free information on there. We do a lot of articles. We have an article called The ABCs of Uses of Special Needs Trust. It just gives examples, just a lot of free information on there. Just with the caveat that we can't update everything, every year. So
Found the 2024 version, so we're good.
Oh, good. Yeah, no, link that too, because that's a good one. It really is. I'm not sure if it's totally Pennsylvania specific, but most of the stuff in there is fully applicable.
I found it as well, so we will make sure if you don't get a chance to snag it from the chat that it will get sent out with the link for the recording as well.
Oh, good. Excellent.
I know we're still talking about how payments and purchases and whatnot.
Go ahead. I think we covered these.
So will the trust pay for someone to accompany the beneficiary on vacation, all expenses such as room, food, admissions, etc.? I guess I'm wondering if that's kind of if an individual goes on vacation, having a support person with them.
Yeah, absolutely. So this is a Social Security rule. So what they say is that the trust can pay for the beneficiary, and then any other people, it can be multiple people, whoever are needed to accompany the beneficiary and keep them safe. So, I'll have a client that their child needs 24-hour care, so they need more than one caretaker. And that's fine. The trust can pay for that. Social Security rules specifically say that you're allowed to pay for the other person's travel and lodging. They get a little specific and say you're not allowed to like buy them souvenirs or clothing for the trip, things like that. But in general, you can definitely pay for the lodging and the travel for other persons as long as they're needed to care for the beneficiary. You don't have to prove any like medical documentation of that. Right now, it's, they'll take your word for it. It's, again, one of those things where you do have to be reasonable. The the trust shouldn't pay for, like, you know, if we're saying, oh yeah, we need all, you know, 5 siblings to go and care for the person, and if the person's like high functioning, that's probably not going to fly. So as long as you're reasonable, though, it's okay. All right, Emily, are there other questions before we turn to ABLE?
I think we're good. I guess, like, I don't mean to, interrupt when the questions come in. I know they happen like as you're talking about certain things, so I want to make sure I get to them before we go jump to another topic.
Absolutely. And I'm also not trying to rush. I just want to be aware of our time frame here.
You're doing great. So I think we're good to move on to ABLE. Thank you.
Perfect. All right, great. So the ABLE Act is not brand new, but it was one of the biggest pieces of legislation that we really had in regard to persons with special needs in quite a while. The federal law was passed in 2014, and then the Pennsylvania ABLE Act was passed a few years after that. But what the federal law did is it said each state can enact their own ABLE Act. And the ABLE accounts are basically savings accounts specifically for persons with disabilities. They're modeled after state 529 plans, so they have some of the income tax benefits of 529 plans, and we'll talk about that. Now, what we'll see, and in the talk, we kind of compare ABLE accounts to special needs trusts. The ABLE accounts aren't really replacing special needs trusts in most cases, but they can work really well in conjunction with special needs trusts. And there are some instances where it's really helpful to have an ABLE account too. So we're going to kind of go through that. So basics first. Right now, to be eligible for an ABLE account, you have to be disabled before age 26. Now, that age is going to increase to age 46 starting in the year 2026. A lot of sixes there. So right now, you have to be disabled before 26, but that is increasing to age 46 soon. Also, like we said, you can only have one ABLE account. So you could have multiple special needs trusts, but only one ABLE account. So if you, like I said, different states are going to have their own ABLE accounts. So there are some Pennsylvania benefits to doing a Pennsylvania ABLE account if you live here. But if for any reason you did a different state's ABLE account, that's fine. You just cannot then open a Pennsylvania one. Now, a big difference between ABLE and the special needs trust is that anybody can put their money into an ABLE account. So we saw with special needs trusts, the beneficiary is only going to put his money into either that self-funded trust or one of the pooled special needs trusts. And then mom and dad are only going to put their money into that non-payback third-party funded trust. But with ABLE, anybody can. So mom and dad can put money in, or the beneficiary can put money in. Anybody can. So that's nice. In Pennsylvania, the state holds the money. So mom and dad aren't going to be able to be trustee of an ABLE account. There is no trustee. The beneficiary, if he is a competent adult, can have direct access to the account. There is no trustee, but the state is going to invest the funds. So there is no trustee with ABLE accounts. So again, that's a big, big difference between the special needs trust and the ABLE accounts. So what that means is if you do have a competent adult child, as long as he is able to do so, he can have control over his own ABLE account and he can withdraw the funds as he pleases. So as you can imagine, this can be a good thing in some cases. It can really increase an individual's independence. He can, feel good that he has a savings account that he can use as he pleases. But again, just be aware that it could make that person subject to like a designing person or a bad actor out there. So we really just have to look and see if this is the right situation for your child or not. If your child is not able to manage his own ABLE account, like if he's just incapacitated and not able to have control over it, then the Pennsylvania account lists like the parties who would be responsible for that account. So it's kind of the closest family members. So it would be parents first, or a power of attorney, or a guardian, things like that. Or if you don't have those, it does go down to adult children, siblings, things like that. And that's all available on the Pennsylvania website for the ABLE accounts. But in general, if you do have a competent adult child, he can withdraw monies from the ABLE account himself. And I should say that another big difference is you do not need to go to an attorney to set up an ABLE account. You just go online and you can do it yourself. Emily, again, maybe you could link the Pennsylvania ABLE account website. I believe it's PAABLE. I always mess it up. PAABLE.org, I think. Maybe it's .gov. It might be .gov.
I think it is .gov, so no worries.
I always mess that up.
No worries. I have it ready, so I'll put it in the chat. Quick question. Could the special needs trust trustee manage the person's ABLE account?
Yeah, they can. They can. Like I said, you'd want to go on the ABLE website and see that list, but in general, they should be able to, yes. So with an ABLE account, the way it works is money that goes into the ABLE account is going to be after-tax dollars. But then while it's in the account, it can actually grow, and you don't have to pay income taxes on the growth portion. And as long as the money in the ABLE account is eventually used for the beneficiary's qualified disability expenses, then we actually don't pay any income tax on any of the growth portion. So that's why it's similar to those 529 accounts. You have that income tax benefit. So what are qualified disability expenses? Well, this slide lists what the IRS and Social Security has told us. It's things like housing, transportation, any type of assistive technology, health prevention and wellness, financial management, things like that. So this was the list that we were given. This is not an exhaustive list, so it's just like examples, but it's not completely everything. The IRS has specifically told us that this list is supposed to, that it is supposed to be broadly construed, and that it's not limited to things for which there is a medical necessity. This is what we have. At this point in time, we do believe that the ABLE account can be used very similarly to how a special needs trust can be used. And we'll probably get more information on that as time does go forward. Like I mentioned, as long as the ABLE account is used for these qualified disability expenses, you don't pay income tax on that growth portion. Theoretically, if it's used for non-qualified disability expenses, then you would pay income tax just on the growth portion, and there is a penalty. Again, that's similar to a 529 plan. Now, a major difference and a super important difference between ABLE and special needs trusts is that the ABLE account can pay for housing expenses, shelter costs, and it's not viewed as income by Social Security. And so it's not treated as that in-kind support and maintenance income or that ISM. So you can use ABLE to pay for rent, and it does not reduce SSI. So sometimes families will put money into the ABLE account and then use that for the rental payments. And let me just go on, because another really important thing that I don't think I got to yet is how much money you can put into the ABLE account. Here it is. You are capped at how much can go into ABLE. So right now it's $18,000 per year. It is tied to that annual gift tax exclusion amount that we have in the law. So the $18,000 is the 2024 number. That should probably go up in 2025, but we don't have that number yet. But with inflation, I expect that to go up. So in general, the maximum amount that can go into ABLE per year is capped at a total of $18,000. So that means if I put $18,000 into my son's ABLE account for the year, we are done. Grandma can't put anything in above that. It's done. So it's 18,000 from all sources combined. It's just a total of that 18. There is one exception to that, and that is if the beneficiary is working. If he is working, he can actually put his earnings into ABLE above and beyond that 18,000, and he can do it up to the lesser of the total amount of his earnings or the federal poverty limit for the year. So if the person is working, he can put more money into ABLE. If your ABLE account is funded with more than $100,000, then the person will lose their SSI. So we may want to keep the account under that $100,000. If they're only getting SSDI, then it's not a problem, and there's no effect on Medicaid eligibility. It's only on SSI. And then the federal law for ABLE does say that states can have a payback for Medicaid provided to the beneficiary from the ABLE account. The payback is limited to just Medicaid provided during the term of the ABLE account. It's not for the lifetime of the beneficiary like our self-funded trusts, but there is still that payback. Pennsylvania has said that they're not enforcing that payback. So if you do have that Pennsylvania ABLE account, then there is no payback there. Just a couple benefits again, if you do live in Pennsylvania and you have a Pennsylvania ABLE account, again, no Medicaid payback. And then Pennsylvania, we do get a Pennsylvania income tax deduction for contributions to the ABLE account. No federal income tax deduction, but you do get a Pennsylvania income tax deduction. And then additionally, the account is not subject to Pennsylvania inheritance tax. So at the death of the beneficiary, we don't have an inheritance tax issue. There is a reporting requirement though. So again, a big difference. Special needs trust, there's no reporting requirement, no affirmative one, at least not in Pennsylvania. Of course, if Medicaid, if Social Security, asks for an audit, you would have to respond to that. You have to respond to that truthfully, but in general, no reporting requirement. But with ABLE accounts, because again, they are held by the state provides the account balances to Social Security. And that means Social Security could look at that. If they say, oh, I see $30,000, got spent from your ABLE account last month. What was that spent on? The beneficiary might have to respond to that. So just to recap, some limits on the ABLE account are that the total contribution amount is limited to that $18,000 per year unless your beneficiary is working. Again, if the account exceeds $100,000, you will lose SSI. The reporting requirement to Social Security, you're still only eligible if you were disabled before age 26. But the ABLE account is particularly useful if you do have an individual who is working. We don't necessarily want them to bump against that $2,000 resource limit, so they can put excess earnings into the ABLE account. If you have somebody who gets, let's say, grandma does leave $5,000 to the child and just left it to that child outright, didn't do that planning in the will, then we can just pop that money right into an ABLE account. We don't have to, go to a lawyer to draft a special needs trust or do anything like that. It's a great vehicle for, smaller amounts as long as it's under that $18,000. If we do have someone over age 65, they can't use one of those self-funded trusts. We might be able to move some money into an ABLE account as long as they were disabled, young enough to qualify. And again, it's just a nice savings account for a competent individual with special needs, can kind of promote their independence and give them a fund of money that they can use as they would like, whereas the special needs trust might hold the greater sum of money that can then be used for things above and beyond that. But the ABLE account is a savings account where they can have direct control over it. Okay. So that, I believe, concludes our slides on that. So Emily, if we have more questions, we can definitely go through those.
Awesome. So we actually had a parent say that they set up an ABLE account for his 11-year-old son, and it was easy. So great feedback.
Great. Good.
And we have a parent, I guess not a parent, if I'm misspeaking, but we have someone where does the ABLE balance go if the disabled individual passes?
Great question. So you'd want to confirm this on the state's ABLE account website. It may vary a little bit for state to state. In Pennsylvania, I believe you can name another ABLE account as beneficiary. So if there are like 2 disabled children, you can name the other ABLE account as beneficiary. But other than that, I believe it's going to have to go to their estate. So again, if it's a lot of money and it goes to their estate, that means we might have to go through like the probate process. If they're over 55, there might be a payback for under that Estate Recovery Act. It can be potentially a little complicated there. I do not think currently you can just name anybody as a beneficiary of the ABLE account. Hopefully they'll change that.
We have one question that just came in. Can you speak to the tax implications of a special needs trust once it is funded, i.e., it has its own EIN and pays on income through trust tax return?
Yeah, sure. So this really is going to depend on the type of trust that you have and on the trust terms. I just have to say that it really does depend on what the trust says. But depending on the type of trust, basically there's 2 ways that it can be taxed. Either it's going to income, and just everybody keep in mind that a trust is a taxable entity, just like you and me. So the trust would have its own tax return. Typically, when you set up a trust, you do get an EIN. It's called an employer identification number, but it's just a taxpayer ID number. A trust doesn't have a social security number. Instead, it has this EIN. So there's really 2 main ways that a trust can be taxed, depending on how the trust is set up. The first would be that the trust is going to pay income tax itself on any income that's generated. So if you have, $100,000 in the account and it's invested and it's generating income, there's dividends, there's, capital gains, things like that. The trust could file its own 1041, the trust tax form, and pay the income tax that way. Trusts do pay income taxes at the same rates as we do, but there's a compressed schedule, so you get to the highest rate faster than we do for individuals. So, it's just the way it is. There's deductions that can be done if certain things are passed out, or if distributions are made. So you want to go to a tax preparer that's familiar with the type of return. Sometimes the trust can be treated as a grantor trust. That means that the income that's generated can be passed out to another person, whether it's mom and dad that set up the trust or if it's the disabled individual himself. Again, it depends on the type of trust and the terms. But if you have that type of grantor trust, the income can be passed out and reported on the individual's personal 1040. That generally is going to have a more favorable income tax result.
Another question. If a DAC has a mod account, do they lose Medicare Part B payments from the state or extra help?
So there's a special Medicaid category that pays for that Medicare premium. Usually you should still be able to be in that. You do have to monitor your income limits though. And your county assistance office and your caseworker there should be able to tell you your exact income limit for that.
And another one, is it only when money in the account is spent do you have to report to Social Security? Do you have to report when money goes into the ABLE account?
No, there's no reporting when money goes into the ABLE account. The reporting requirement is actually done by the state. So Pennsylvania would provide the monthly account balances to Social Security. That's where the reporting comes in.
Great questions. Thank you so much.
Mhm. Yeah, really great questions.
Yeah, I know we're almost at time, so I do want to be mindful of that. I'm sure that I'm sure parents and individuals can have, a bunch of questions on this topic. I guess Miranda, would you be able to stop the recording in case anyone has any specific questions?
Absolutely. So we will stop the recording